Hi friends from around the world. I have my cap on, so this is the last session of that series on the European design system. So if you didn't have the chance to look into the different videos, this is the video at least to have a look at in order to get an overall view on what is the European design system, the different features. And so you can afterwards, if it has the occasion that you want to go know something more about the European design system, to go to the videos, either to the entire series or to the different videos on the different subject matters. Now, we talked about, this is a kind of wrap-up session, right? So I will give you an overview of what we have seen. So you can wrap up and think whether you got the gist of it. We talked about the design. So the designs was a bit in the middle of everything. It touched on copyright because it may be a kind of artwork. It may have touched trademarks because you have the 3D trademarks. You have registered designs and unregistered designs. That is a possibility. And you have maybe, so they call the designs something like small patents or design patents. So there may be also an innovation aspect into them. But designs are designs. It is the appearance of the product, and that is what is protected, right? So we went about strategic considerations. Well, on the strategic considerations, there's one issue more you should think about. On my opinion, what you should think about is also an efficient system, portfolio management. So rather than going, well, I will protect everything and under each angle in order to be sure, in order to feel secure, then you may have a kind of a firework, an explosive firework of protection. But then afterwards, when something really went sour and you get into pressure from somebody pressuring you with some right, and you want to take out the guns and you don't have guns anymore because the firework, the gunpowder has gone. So the efficient management of your portfolio should focus on what do you need for protection, where do you need the protection, because protection is always a kind of territoriality based. So you would first design or designate your home market. Where is the market where you want to sell? And naturally there you look for a kind of protection. And then you would look for expansion market in the future. Once you get some traction, you want to see where I can get to sell more. And these markets should also have some exposure of protection, even if it is only if you rely on copyright, but you know what copyright implies and how it may evolve in the future into something of design protection. You think of priority. If you have a priority, so priority is half a year, so that is an issue to think of. Or you have the deferment possibility that you have to think of, or you have the grace period. So if you file the design afterwards, after 1 year in another country, perhaps you lose the novelty. So there are strategic considerations all over, and this is the important part you should bear in mind. And put the strategic considerations with regard to your IP portfolio on top of what would be the business strategy. What you want in reality to protect is your business strategy, right? So, and you have to look for the IP strategy to put this wrap it around, if you want, around your business strategy in order to succeed with them and to protect it from any attacks of the competition, So that is about the strategic considerations, and do it efficiently, right? Not protect it with with copyright, with unregistered designs, with registered designs, and with trademark, all of once. No, that is not necessary in one territory. So if you can rely on one sound protection, then you are still okay. And then you won't use other funds which you will not use for that home market. You will use it for protection in other territories where this may be an issue, may become an issue in the future. And you will monitor the market where, if you got traction, where eventually fake products are produced, and you may want to protect in that market as well to get to the source of any problems and not have to run after once it enters into your home market and the damage is done. So these are the things on strategic considerations, more or less. And then we went over some concepts. So the novelty is the first thing which we went over. It must be new. So the design, in order to be registered, must be new. Although this is not being examined by the examiner at the moment of filing, but it is an issue, always an issue, or nearly always an issue, once you get an invalidity request. Be reminded that the filing, or the registration, if you want, the registration of the design does not have a filter which either executed by the examiner or by the third parties, that there is no other new design. So the examiner will not do it, and the market will not do it unless it makes an invalidity request. So the invalidity request is, so to say, the filter of the market, where the novelty of your design will be put to a test. So on the novelty, you know that you need a disclosure of the sign, and you need the sign must be earlier with regard to the design protection, right? And then the design holder has the possibility, if it is something which is disclosed, outside the EU where you have the protection, then you have the possibility to refute your knowledge of that earlier sign, because in normal trade that would not be possible that you get the knowledge of that sign. But this is up to the design holder to prove. The novelty is up to the invalidity requester to prove. So this is about the novelty issue, a very important issue with regard to design, and a filter which is applied only through invalidity requests. So do not be, I have a design registration, so I'm good. No, that is not the case. In trademarks it's different. So you have an opposition before registration. So opposition is a kind of filter being done by third parties who have also rights, and if they have better rights than yours, then you get an opposition, and after the opposition, if it is favorable for you, you get registration. So then you have a kind of a position which has passed that filter, right? So then you would go to the filing, you would make a filing, and the filing is very easy to be done. You take the form, you're doing the internet, you have 7 representations to be done, doing the representations right, with no background, no diversion from what it is. You may want only part of it protected, so you use dotted lines for the ones not protected, etc. You pay, you have the current account possibility, which you can or cannot use. Otherwise you have to pay at the moment the fee, which is actually 350 euros. So that is the filing issue. The validity request you get naturally afterwards, right? And the invalidity request goes after the novelty if the novelty is not an issue. So if in any case the earlier sign is novel, then we have to go over the individual character. In fact, that is what the examiner does within the invalidity request. So individual character, what implies this? That implies implies different things. The first thing would be the determination of the informed user. Informed user, that is, so to say, the standard person against which you have to make the comparison of the two signs. So the informed user, that is not somebody as the average consumer with regard to trademarks, that is somebody of a higher knowledge. It's not an expert, but it is, so to say, nearly an expert. It goes to trade fairs and to specialized outlets. It knows a bit about the kind of designs which we have here in front of us in a specific case. And with regard to designs, the additional information is also, it has to be designed for certain goods, right? Not services, must be goods. And there's a Locarno classification. You will do this in the filing, and you need to identify the goods for which you want to protect the design. So if we compare the two signs in the invalidity request, we have goods and services of the one and the other. So you would take then the informed user of these goods and services to a level where, well, you have a kind of nearly expert or, well, very informed user who knows about what these goods are. So this is the informed user. And then the next step of the examiner would be, in the comparison of the signs, right, would be to look at the freedom of the designer. The freedom of the designer is to put out the technical function or the regulatory issues, and would say, well, what can the designer do regarding these products? Has he a lot of creativity which he can apply to the goods in order to be very attractive, or is it that everything is being done with a functional and he can't do much about it? This has to do with the attention the informed user would display, would look at the signs. So if there is a lot of possibility for the designer to make a singular creation out of that goods, then the attention level would be less, and the other way around, it would be higher. And then you will come to the third step, the overall impression on the informed user of the two designs, right? So we would look on what is the designs when I come them through, and I look at one and the other. Would I see the different, or is it that I say the informed user, so a fictive person, right? So it is not the examiner who says, I would say they are. No, he has to put themselves in the fictive person of the informed user to assess whether that fictive person would say, well, this is new for me, or would say, no, that they're identical, so the earlier sign is earlier with regard to that one. And that is, at the end, the individual character. If the overall impression is the same, then the design registration is cancelled due not having individual character. And the other way around, if the design registration is new with regard to the earlier sign, then it would have own individual character. So the individual character is only relative to that proceeding, because in a new invalidity request, which you may get from another design registration or another sign, which is possible, copyright sign or other signs. So the Article 25 of the design regulation is quite important here. With regard to all the earlier signs, it listed all the earlier signs with regard to this. Now, this is comes to an end then. So this is the invalidity request, right? So you would then, we went over the appeal proceedings, so we can go and appeal, judicial proceedings. Well, this is more or less the same with regard to trademarks. You may go there as well. So enforcement. On the enforcement, we looked at community design courts, just as community trademark courts. So there are some courts within the European Union, which are responsible of not about the application or not of the cancellation of the design. In fact, no, they are. If you have damages against another company due to infringement of your design, then you would go to a community design court. Damages will not be agreed to you by EUIPO. It has no competences on this issue, right? So community design courts, that is a possibility to go to you. Each member state has designed some courts, 2 or 3 or 4 courts, and even appeal courts with regard to that. So you would go to these courts. But in a counterclaim, you also can cancel a design registration if you are sued on the basis of a design registration, right? But that is a possibility as a counterclaim in the community courts. And finally, we talked about the monetization. And just one word on monetization. You know all about licensing. You have heard about spin out. You have the cooperation. There are different possibilities, but you have probably not heard about the tokenization. And this is an industry which I want you to have a look out in the future. It may have, especially for the business owner, it may have a major impact into IP rights, as it had in the past. Impact into it is in fact about digitization, right? Digitization of an industry. And in this case, the digitization, has to do with tokenization, with putting into different segments, so to say. You do not need to lose the whole IP right through a contract with a different party. No, you can license out part of that only for one territory, but for that territory, it is for you somehow difficult to make the use of it is more, I would say it will become more important for patents, and I will go into that a bit more deeper in the patent series, which is still to come. So that was it, more or less. Hopefully it was helpful for you and you found some value. If so, please like it, put the thumbs up, or mail it, share it with somebody who might be interested. Thank you very much, and see you next time.